This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when fraudsters are imprisoned and yet keep working at their fraud, and why in one case in Louisiana, fraud plus multiple arrests and convictions requires the defendant to serve his full sentence, and why compassion needed by victims, not by the fraudster, and serious and a dedicated criminal loses his request for early release. In the United States of America versus Chad Lightfoot, the United States District Court for the Western District of Louisiana on May 6, 2025, dealt with a motion for compassionate release filed by defendant Chad Lightfoot. The United States of America, of course, opposed the motion. Lightfoot is an incarcerated inmate with the Bureau of Prisons. He filed a motion requesting compassionate release under 18 U.S.C. Section 3582C1A. Lightfoot alleged extraordinary and compelling reasons warranting relief based on the criteria set forth in U.S.S.G. Section 1B1.13. Lightfoot made false and fraudulent representations to procure funds from a federal disaster relief program. Lightfoot claimed that his residence in Monroe, Louisiana, sustained damage from a flood when in fact Lightfoot was living in New Orleans during the time of the incident. After a 4-day trial, a jury convicted Lightfoot on the sole count of the indictment. The court sentenced Lightfoot to 71 months imprisonment, followed by 5 years of supervised release. Lightfoot is expected to be released on December 5, 2025. On February 26, 2024, Lightfoot filed this motion for compassionate release. Generally, a district court may not modify a term of imprisonment once it has been imposed. However, Section 3582 sets forth narrow circumstances where a court may reduce the term of imprisonment and impose a term of probation or supervised release with or without condition that does not exceed the unserved portion of the original term of imprisonment. The court may only grant that type of relief when the defendant shows that 1, extraordinary and compelling reasons justify a sentence reduction, 2, such a reduction is consistent with applicable statements issued by the Sentencing Commission, and 3, early release would be consistent with the sentencing factors in Section 3553A. Lightfoot, therefore, must demonstrate that extraordinary and compelling reasons warrant reducing his sentence. The Sentencing Commission set forth 6 specific reasons that can be considered extraordinary and compelling. They are 1, the defendant's medical condition, 2, the defendant's age, 3, family circumstances, 4, whether defendant has been a victim of abuse during custody, 5, other reasons that are similar in gravity to reasons 1 through 4, and 6, an extraordinary long sentence. Lightfoot points to his family circumstances as the basis for his motion. Specifically, Lightfoot claims his 4 minor children need his financial and emotional support. His mother is suffering from dementia, and he is a possible organ donor candidate for his sister's kidney transplant procedure. Lightfoot does not, according to the district court, meet or satisfy any of the family circumstances. Even if Lightfoot showed extraordinary and compelling reasons for granting relief, the analysis doesn't end there. Lightfoot's prior conduct speaks for itself. Lightfoot has been arrested and convicted for several crimes, including armed robbery, simple and aggravated assault and battery, bank fraud, insurance fraud, and forgery. His last offense involved a fraudulent scheme to receive thousands of dollars from a federal disaster relief by falsely claiming that his Monroe residence sustained damage from a flood. Such offenses pose a danger to the community and reduce the available funds for those who are truly victims of the floods. The United States District Court concluded that releasing Lightfoot would be contrary to the Sentencing Commission's directive that courts should deny compassionate relief to defendants who pose a danger to their communities, because defendants' fraud scheme lasted over a year and caused grave financial and emotional harm to his many victims. Lightfoot's motion for compassionate release was denied. In my opinion, Chutzpah is defined as a person who murders his parents and seeks mercy because he is an orphan. People who commit fraud are by definition people with unmitigated gall. It takes chutzpah to commit fraud successfully and to attempt fraud over a long period. After being convicted and sentenced, Mr. Lightfoot tried to cut about a year off his sentence by claiming he needed to care for his 4 children and to take care of his sick and demented mother, and maybe even give part of his kidney to his sick sister. However, the U.S.C refused because of the clear danger he presents to the people of the state of Louisiana. Lightfoot's attempt to reduce his sentence was found by the United States District Court to be a perfect example of chutzpah, and he will serve his full sentence. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 5,050 blog postings. You can also subscribe to these videos on rumble.com or youtube.com. They're all free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.